Welcome viewers to this video in the series of Media Ethics and Laws. If you are a student of IGNOU pursuing your PGJMC or MAJMC, then this is your course MJM025. And today we shall talk about Unit 9, which is the first unit of Block 3 of this course. However, if you are a layperson who has tuned in to this video today for some general knowledge, you will not be disappointed. We shall discuss the intellectual property rights, the laws in India and internationally related to the IPR. And this, of course, is useful for all of us as academicians, as students, as professionals, and these days even as social media users, because we are not only users, we are also producers of the content. We put out videos, reels, photographs, comments, stories, blogs. So all this and more, is it protected by IPR? If yes, how? If no, why not? We shall talk about these issues in this Unit 9 on IPR. As always, let me take you through the unit structure, which is the unit how it is structured in your print material, which is your self-learning material. Let me also tell you, if you are an IGNOU student, this print material would have come to you in the book format if you are opted up for it. However, even if as a layperson you wish to go through it, all this material is copyright free and available on our platform eGyanKosh, which is www.egyankosh.ac.in, and you can freely download, access, read and take knowledge from this material at IGNOU. Why am I telling you this? Because this comes under IPR. IGNOU holds the copyright for that material, and IGNOU has made this material into a Creative Commons material. That means to all and everyone it is accessible, because knowledge should not be bound, it should be free to share. With all this gyan, let's come to the unit structure. In this unit, we shall begin with the concept, nature and scope of IPR, where we shall define, discuss the importance and scope of intellectual property rights. Then we shall go on to talk about the evolution and growth of IPR, in which there are important milestones like the Paris Convention, Berne Convention, Journal Agreement on Tariffs and Trades, and the Rome Convention, which will be talked about, which will lead us to the World IP organizations, what are their objectives, what are their programs and activities, and then the emergence of the new trading system, which has WTO and TRIPS, that is WTO and TRIPS, and then the components of IPR, which is patent, trademark, copyright, industrial design. All this will be discussed in this unit. You more or less know what to expect out of it. Still, as my duty, let me provide you an introduction. Today's development and growth has actually made possible the outcomes of human intellect, which need legal protection worldwide. And by this, we mean the emergence of the new media, which has shrunk the world to actually a global village. In this unit, we shall give you an overview of the various aspects of IPR. Is in the increasingly globalized world that it has become important for you to be aware of this very important international law. As for the learning outcomes, after you have gone through this unit either in your print material or through this video, we expect you to be able to discuss, describe, get acquainted, explain and put to numbers certain concepts, which is you can expect yourself to be able to discuss the concept and nature of IPR, to describe the evolution and growth of IPR, acquaint yourself with WIPO and new trading systems, explain the importance and consequences against the IPR regime, and also to be able to enumerate the various legislations that are available for IPR. With so much of talk about it, what is actually the concept and nature of IPR? Intellectual property broadly means the legal rights which result from intellectual activity in the industrial, scientific, literary or the artistic fields. IP, which is intellectual property, refers to the ownership of an idea or design by the person who actually came up with it. If we have to define it, then according to the World IP Organization, IPR refers to creations of the mind, inventions, literary and artistic works and symbols, names, images that are used in commerce. It is something which is economically and commercially being used, or something which is published as an academic thing, as an artistic play, song, whatever. All this is covered under the IPR. Let us more officially clearly define the IPR. The concept of property has existed from times immemorial. You have not started composing poems or writing stories just today. The concept of the intellectual property is as old as the human civilization. Encyclopedia Britannica defines the term intellectual property as a property that derives from the work of an individual's mind or intellect. Simple. Since IPR is a right over an idea, so it also covers everything that is under this idea. That means propagation of the idea, execution of the idea, writing of the idea, legality of the idea. So all this is covered. Now this makes us very, very important. What is the importance of IPR? IPRs are vital for economic growth. For example, if I'm putting out an industrial design and everybody can use it without my knowledge, why would I put that interest, that hard work into it? Therefore, to promote the economic growth, and also this allows the owners of the intellectual property to derive financial benefits from the property that they have created. Intellectual property helps in the generation of breakthrough solutions to some major global problems. You would ask how? Okay, let us give you an example. Nearly all the 300 products that are on the WHO, World Health Organization's essential drug list, which are crucial to saving or improving people's life around the globe, came from the R&D, which is research and development intensive pharmaceutical industries that depends on the patent protection. A pharmaceutical industry puts in a lot of hard work and scientific rigor to come up with life-saving drugs, and then they get them patented so that nobody else can just use them. So this is very, very important. IPR encourages innovation and rewards entrepreneurship. Any new idea, any innovation is being rewarded because it is protected. Now you would understand, yes, it is very important. Please tell us what all is covered under the scope of IPR? Well, friends, you thought of it and we have given it to you. So the scope of IPR covers literary, artistic and scientific work, performance of performing artists, phonograms or even broadcasters, inventions in all fields of human endeavor, scientific discoveries, industrial design, trademarks, service marks and even commercial names and designations. It gives you protection against unfair competition and all other rights that result from intellectual activity in the industrial, scientific, literary or artistic fields. So this is a very broad scope for the IPR. Now what is the next question coming into your mind? You're getting interested into the topic, I can sense that. So now you're asking me, is it so new? How did it actually evolve? If IPR and intellectual property has been existing, how did we come to giving rights for this intellectual property? Friends, this has not been easy. It has been a long journey. Let's trace the evolution of IPR and its growth. The growth of intellectual property rights can be seen in the light of two major conventions for the protection of IPR, which is the Paris Convention for the protection of industrial property, which was in 1983, and the Berne Convention for the protection of literary and artistic work. These two conventions have undergone various changes since when they were held initially, and they have been brought under the supervision of World Intellectual Property Organization, which is WIPO, W-I-P-O, which was constituted in 1967 as a result of a treaty which was signed in Stockholm. The Agreement on Trade-Related Aspects of Intellectual Property Rights is an international legal agreement between all the member nations of the WTO. So whosoever is participating in World Trade Organization is bound by these agreements of these conventions. Now let's talk of these conventions. What were they actually? So let's start with the first one, which is the convention held in Paris in 1883. The Paris Convention, this is the name it is known by, for the protection of industrial property was signed in 1883. This is one of the first and most significant international treaties that is designed to help people in one country obtain protection for their intellectual property in other countries as well. Otherwise, you know what would happen? You have given a new idea or written a story, a poem, or a dramatic thing, or you've made an industrial discovery, because this convention specifically talks of the industrial property, industrial designs or something, some product design. You've created a design in, say, India, and can you use it in Denmark or in Philippines or in Finland? No, you cannot. If you are protected by the IPR in India, then this treaty, which is the Paris Convention of 1883, it says that you are protected in all the other participating countries. They are known as the participating states or the contracting states of the contract. The key features of the Paris Convention include: it is applied to industrial property, including patents, trademarks, industrial designs, utility models, service marks, trade names, and even geographical indicators. It ensures that each member country provides the same protection to nationals of other member countries as it provides to its own nationals. It provides a right of priority. That means if an applicant files for protection in one member country, they can file in any other member country within 12 months for patents and even for utility models, or within 6 months for industrial designs and trademarks, and they can benefit from the first filing. So if it is taking time in, say, one country to issue you this patent or trademark, you can actually also go and file in another country, and whosoever issues you the patent trademark right first, you can have that protection from that first issuing nation. This convention is very important as it facilitates international cooperation and recognition of intellectual property rights, and it also helps the creators and business prospects in their IP being offered in multiple countries very, very efficiently. Let's quote certain things from the Paris Convention for your better understanding. You do understand why it is important, what it is, how it is defined. To quote, we can say about industrial design. Industrial designs must be protected in each contracting state. Contracting state means the participating countries. And the protection may not be forfeited on the ground that the articles incorporating the design are not manufactured in that very state. So even if you're manufacturing in one country, you can go and claim your protection of IPR in another contracting state. About the trade names, the Paris Convention says protection must be granted to trade names in each contracting state without there being any obligation to file or register the names. About the indications of source, Paris Convention maintains measures must be taken by each contracting state against direct or indirect use of a false indication of the source of goods or the identity of their producer, manufacturer, or trader. This convention protects you under unfair competition. Each contracting state must provide for effective protection against unfair competition. So this is about the importance of the Paris Convention. This all began much before, even before the 1900s. In the 1883, this agreement was signed by the contracting countries. And as a progression, we come to the next convention, which is very important in what we know IPR today as. Today, what we know intellectual property rights as have been resultant of all these efforts. The Berne Convention. The Berne Convention for the protection of literary and artistic works was established in 1886. It is an international agreement which aimed at protecting the rights of authors and creators over their literary and artistic works. So the Paris Convention dealt with the financial, industrial, trade kind of things, and this deals with the literary and artistic works. The key features of the Berne Convention are: it ensures that works created in one member country receive the same protection in other member countries as they do in their country of origin. There is an automatic protection without the need for formal registrations. It protects a wide range of works, including books, music, films, paintings, and even softwares. There is a minimum protection duration of the author's life plus 50 years, although many countries have exceeded this to even 70 years or more. So till the author is alive, and even after that, from 50 to 70 years, the literary and artistic work is protected under the Berne Convention. And therefore, it is a very important convention because it promotes creativity and cultural exchange by ensuring that authors and creators are compensated for their work, and it also harmonizes copyright laws across the member countries, making it much more easier to protect and manage rights internationally. what are the rights given by the Berne Convention? So, friends, subject to certain allowed reservations, limitations, or even expectations, some of the rights that are recognized as exclusive rights of authorization or authorship by the Berne Convention are the right to translate, the right to make adaptations and arrangements of the work, the right to perform in public dramatic musical or musical works, the right to recite literary works in public, the right to communicate to the public the performance of such works, and the right to broadcast, with the possibility that the contracting state may be provided for a mere right to equitable remuneration. All these and even more rights are covered by the Berne Convention. So if you're interested, I would suggest and I would encourage you to go ahead and read more about this convention. This brings me to the third very important, I would say, step in the intellectual property rights, which is the Rome Convention. The Rome Convention for the protection of performers, producers of phonograms, and the broadcasting organizations was adopted in 1961. This is an international treaty which was designed to protect the rights of performers, phonogram producers, and broadcasting organizations. Friends, do you see this step-by-step development? From the industrial design, we came to the literary and creative works, and now the convention about the broadcasters and their protection of rights about their phonograms, productions, programs. So this is covered by the Rome Convention. The key features being, this grants performers the rights to prevent unauthorized recording and broadcast of their live performances. It provides producers of phonograms, which is sound recordings, the right to authorize or prohibit the reproduction of their recordings. The Rome Convention also ensures broadcasting organizations can control the rebroadcasting, recording, and reproduction of their broadcasts. A protection period, generally, which is about 20 years, this is given from the end of the year in which the performance or the phonogram or the broadcast took place. So whenever this happened for the next 2 decades, you're protected as per the Rome Convention. Therefore, as students of media, as professionals practicing the broadcasting media in some way, this becomes very, very important for us because the Rome Convention strengthens the economic rights of the artists, producers, and broadcasters. It encourages investment in the creation and dissemination of cultural products. It also harmonizes protection across member countries, promoting international collaboration and trade in the creative industries. Let me give you certain quotes from the Rome Convention Treaty. Performers are protected against certain acts in which they have not consented, such as broadcasting and communication to public of a live performance, fixation of the live performance, reproduction of the fixation of the performance, or if the original fixation was made without the performer's consent. All this is protected under the Rome Convention. The producers of phonograms have the right to authorize or prohibit the direct or indirect reproduction of their phonograms, which is the sound recordings. So these were excerpts from the Rome Convention to give you an idea. If you feel interested, go ahead, read more about it. I would discuss very briefly the next things, which is the General Agreement on Tariffs and Trade, which is acronymized as GATT. So GATT is the product of growing realization by the member nations that their relations in the field of trade and commerce should be conducted to raise standards of living, ensure full employment, develop the full use of resources of the world, and even to expand production and expand the usage of such produced goods. GATT aims to achieve these objectives by providing reciprocal and mutually advantageous arrangements directed to the substantial reduction of tariffs and other barriers on the trade and elimination of discriminatory treatment in international commerce. So the realization that if we have to grow, we grow together brought about this trade agreement. And from this emerged the World IP Organization, which is WIPO, you can call it, WIPO. Now, WIPO, or World Intellectual Property Organization, is a landmark event in the history of promotion and protection of IP rights at a global level. The convention establishing the WIPO was actually signed in Stockholm, like we said earlier too. The WIPO has been designed as a specialized body at United Nations and is also acting as a complementary body with WTO as far as the promotion and protection of IPR is concerned. Now, what are the objectives of this WIPO? The objectives are to promote the protection of intellectual property throughout the world through cooperation among states wherever it is appropriate in collaboration with any international organization. It aims or it has the objectives to harmonize national IP legislation and procedures, to provide services for international application of IP rights, to exchange information on intellectual property, to provide legal and technical assistance to developing some of the other countries, and to facilitate the resolution of private IP disputes. With this and even many more objectives in mind, there are certain programs and activities that WIPO runs. I'll just glance you through or take you through briefly about what are the activities that WIPO conducts. It has the role of advising and even giving the expertise in revision of national legislation, particularly in the importance for the member countries. It has a comprehensive education and training programs for the nations that are engaged with it. Extensive computerization assistance is provided to the member nations to help them in developing and acquiring the information technology resources that would help them in streamlining the administrative procedures for managing and administrating the IPR. And it also gives financial assistance to facilitate the participating nations in WIPO activities for the meetings, for certain progressive activities. So training, financial assistance, resolution of conflicts, all this comes under the prerogatives and the programs activities of WIPO. Now friends, there is a very important thing which is the new trade system. Let's talk about it briefly. How did this emerge? What does it mean? What does it take care of? The successful conclusion of the Hirogia round of trade negotiations actually gave the way for a new era of profound significance for the emerging trade systems. The Hirogia round negotiations formally began in 1986 and took 7 years for its conclusion on December 15, 1993. And thereafter, the final act was signed in 1994 on April 15. As a result, World Trade Organization replaced GATT. So now instead of GATT, we have WTO. Now, what is WTO? The World Trade Organization is considered as a landmark in the history of multilateral trading systems. Although there are many criticisms on WTO, like the economic interests of developing countries are compromised, and about the labor, which is not actually regarded as nicely, or the environmental things, but yet IPR in this field, WTO remains very significant. One of the major agreements having far-reaching impacts on IPR is the Agreement on Trade-Related Aspects of Intellectual Property. Now, WTO leads us to TRPS, which is Trade-Related Aspects of Intellectual Property Rights. As we said, WTO has many domains, but for our concern today that we are discussing IPR, we are more concerned with TRIPS. Let's discuss TRIPS in detail. If we have to define and put out the purpose of TRIPS, TRIPS is an international legal agreement between all the member nations of WTO, which was established in 1995. Its main objective is to harmonize the protection and enforcement of the intellectual property, IPR rights globally, ensuring that IPR does not become barrier to the trade practices. The scope of protection under TRIPS is TRIPS sets minimum standards for the protection of various forms of intellectual property, including copyrights, trademarks, patents, industrial designs, geographical indicators, and even trade secrets. It requires member countries to provide strong IP rights and effective enforcement of the mechanisms to protect these IP rights. The impact and significance of TRIPS remains by establishing a unilateral set of rules. TRIPS aims to reduce distortions and even implementations of the international trade, to promote technological innovation and facilitate the transfer and dissemination of technology. It helps in creating a predictable and secure environment for businesses and innovations, fostering economic growth and development within the consenting nations. Now, as per TRIPS, what are the components of IPR? The components of IPR, as envisioned by WIPO and TRIPS, have specified aims and objectives. Let's go through a brief explanation of each of these components of IPR so that tomorrow, when you are creating things, you need to be aware as students of media. The first component of IPR that is given by TRIPS or earlier by WTO is patent. Now, John of Utane is the recipient of the first known English patent, which was granted in 1449 by King Henry VI. Any person whose invention has novelty involving intensive steps and of industrial application can be granted a monopoly right for a specified period to commercially exploit the invention and to earn profits out of his or her invention. There is a landmark case which is Novalities versus Union of India case, in which the decision by the Supreme Court of India in 2013 came out about the patent. Now, I would encourage you to go ahead and read this case so that you understand more about the patent. Here, we can just give you the definitions and maybe certain landmark decisions on it to give you a fair idea. We come to trademark, which is the second component of the IPR. Trademark is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. Now, the system helps consumers to identify and purchase a product or service which is based on whether its specific characteristics, quality as indicated by the unique trademark. So, trademark is a visual representation which, as a customer, as a purchaser, as a user, helps you identify the product. Trademark protection ensures that the owners of the marks have the exclusive right to use them to identify goods or services and also to authorize others to use them in return of payment. So anybody who can be authorized by the owner of a trademark can actually gain from it financially. The next component is the copyright. By definition, the subject matters of copyright are literary, artistic, dramatic, musical, cinematographic, or films or sound recorded works. A copyright owner has sole and exclusive right of multiplying the copies of the original work and publishing and selling them for a specified period. For this, there was a judgment. The High Court found that the defendant's website using the name crorepaticorn.com with the logos and names and identical photographs of the plaintiff's TV show, which was Kaun Banega Crorepati, was an act of infringement of the plaintiff's copyright. So in India, there has been this case which actually says something similar can also be thought to be the infringement. The name is different. Right? It is not Kaun Banega Crorepati. It is crorepaticorn.com. But still, the High Court actually gave a judgment, no, this is a copyright infringement. So such and many more cases become landmarks and stepping stones in deciding what it is what we live in the world today. So what we know today has been a result of many judgments. It has been a result of many steps, conventions, issues which were raised by people. World would not have been the same if not for some people who dared to come up with these issues and take them to the court. Actually, this brings me to the next part of the IPR, which is the geographical indication. This is an indication which identifies goods such as agricultural goods, natural goods, or manufactured goods as originating in the territory of a country or its region where it has come from. So you have to indicate the name of the country or the region. These indicators denote quality, reputation, and even other characteristics of the goods. The right conferred on geographical indication prevents competition from commercially exploiting the respective rights of these products. And now we come to one of the very important and the last components of IPR, which is industrial design. Let me go a little more in detail about this, being the last component. By definition, industrial design refers to the ornamental or aesthetic aspect of an article. It may consist of three-dimensional features such as the shape or surface of an article, or two-dimensional features such as patterns, lines, or even color. Now, the purpose of the industrial design is to protect the visual design of the objects that are not purely utilitarian, something which is abstract. which you can't touch. You can't like purely, it can be considered as utilitarian. To protect them, the concept of industrial design has been put in IPR. It encourages creativity and innovation in the design of the products. Key features of industrial design are: it must be new and original. It should have visual appeal and be capable of being applied to an industrial product. As for the protections for the industrial design, this IPR law provides exclusive rights to the owner to prevent others from making, selling, or importing designs bearing or embodying a design which is a copy or which is substantially seen to be a copy of the preceding design. It also has a protection period that varies by country to country, typically lasting 10 to 25 years. Examples of industrial design can be product packaging, furniture designs, textile patterns, or even consumer electronics. So patents held by, say, the Sony television, that this is a technology and for these many years no other television company can use it, is an example of the protection under the IPR Act of the section of industrial design. So friends, we did look at IPR and its various components, discussing industrial design just for your benefit a little more in detail. This brings me to the end of this unit, which is Unit 9, Block 3, first unit of Block 3, Unit 9, which is on intellectual property rights. Just to give you a summary of the unit, in this unit it was explained that intellectual property broadly means the legal rights which result from intellectual activity in industrial, scientific, academic, artistic, or literary fields. Intellectual property is a term which is used in property laws and it refers to the ownership of ideas or designs by the persons who actually came up with it. We discussed the important milestones in this, like conventions of Paris, Berne, Rome. We discussed certain agreements, WIPO, WTO, TRIPS, the IPR law, and we summed up and wound up with the components of the IPR like copyright, industrial design, patents, some others. I hope this was interesting enough as intellectual people, as media people, as journalists, as professionals, as students, as academicians. Knowledge about IPR is very, very important for us. And the unique thing about IPR is that it is evolving by the day. It is not something that remains. So if you've heard me out today or read into a IGNOU material, it would have evolved by the time you listen to this video or read that material. So please go ahead and look at the latest development in the IPR, which is global and even national in India. With this kind of a teacher encouragement to go research, find out and know more about the topic, I would wind up with something that I say every time: curiosity keeps you going. Curiosity is the answer to learning and enjoying that learning. Wishing you a curious, happy learning experience. Thank you so much for tuning in and listening to this. Thank you.